This week we're going to focus on legal contracts and why a handshake agreement is often not enough. Just recently, I hosted a panel with a couple of experts in this area, and we're going to spend some time with them today. First of all, thank you for being here. If you were to put in one sentence, why should a farm family put some contracts and agreements in place? Ray, what would your answer be?
I'd say it's about managing risk, increasing certainty, not relying on this notion of trust when the word itself is really hard to define. And the word trust means different things to different people. So essentially what we're trying to do here is add some certainty for both the successors and the founders, and also manage the risk, reduce risk in the form of a transition.
Well said. What do you think, Andrea?
So there are operational documents that you might consider in terms of how do we organize ourselves as a business? Are we a partnership? We need a partnership agreement. Are we a corporation? Perhaps we might need a shareholders agreement. Are we a joint venture? In which case we need a joint venture agreement. These are the operational kind of documents that are really useful oftentimes and overlooked in farm families. Moving to succession documents, that's where we get into more of those agreements for sale and those sorts of things, the transitional kind of documents that might be useful in those situations. And then lastly, the estate planning documents that are perhaps those might be more described as the finish line documents.
You had said a way that you described it was about how we're going to play in the sandbox. So what does that mean?
Think of a sandbox as the parameters of a relationship. So you have the four corners and we understand what are the rules in this sandbox, and we will be in this sandbox together, and how will we treat each other? How do we get into the sandbox? How do we get out of the sandbox? How do we work together in the sandbox?
So if you were to sum up the critical documents that's in, if you're looking at a suite of estate documents, what would you describe?
In my experience, the three critical documents for estate planning are the will, which of course speaks after you've passed away, the power of attorney document, which is active during your lifetime, can be conditional or unconditional, lots of specificity around that. And lastly, a healthcare directive, which is a document that allows somebody to make decisions for you if you can't regarding your healthcare, and also speaks to some end-of-life decision-making questions as well. These, of course, everybody should get really good advice within their province about those documents. It can vary from jurisdiction to jurisdiction.
And I just wanted to add on to what Andrea was talking about, what you brought up about the documents or the suite of documents. Sometimes what's overlooked is, where do we find these? Mom and Dad have been around for a long time, and it's a big house. Where do they keep this? And I think the notion of having, for lack of a better words, a death binder, where you can have all of your agreements, your will, healthcare directives, powers of attorney, life insurance documents, your banking information, your contact information for your legal advisor, your accountant, and so forth, where the family knows that if something happens, worst comes to worst, you go into this closet, you look up there, and this is where you're going to find everything out about what you need to do.
It's something that I think can get missed. You can spend a lot of time developing this. It's custom for your farm. It absolutely has all of your wishes in mind, but if it can't be found, right? Keep that in mind. When you're thinking about creating a will, what should a person aim to accomplish in terms of that will document? Where should they be aiming?
So the will speaks after somebody passes away. So it does two main things. It describes who will manage the estate and how will the estate be managed, who gets what, and how do we treat the assets after somebody has passed away.
So then, equally so, what should you not expect from a will?
It can't solve all of your operational problems. It can't solve your succession problems, but in and of itself, it's not a magical document that can do all of these other things.
So then how do you deal with that, Ray? Do you have any thoughts?
One of the missing elements in a will is conveying to the audience, to the beneficiaries, why you've structured it the way that you have. Often it's a fairly dry document. X gets one asset and Y gets another asset. And there's not a lot of rationale put in behind it. And unless there's been clear communication with the family as to why we're doing it this way, it can lead to uncomfortable conversations in the future. It can lead to real debates, and it can lead to arguments, and it can lead to disputes, which need to be resolved by bringing in legal people to help them deal with that. Another option is to put your rationale into a separate document, separate from the will, have your lawyer review it to ensure that there's no outright conflicts between it and what the will is saying, and include it in the same envelope as what the will.
How long should I expect my will to reflect my situation and my wishes?
So my recommendation to clients is every 3 to 5 years. Take it out, dust it off. If it still makes sense, if the people you're naming in that document are still around, or if somebody's passed away, or your relationship with them has changed, these things can happen. I know in my office we'll diarize it for 3 to 5 years to follow up and say, hey, does this still make sense? Does this match? And if it does, perfect, put it back away. If it doesn't, great. Here's our opportunity to refresh.
So when I'm talking to farms, one of the things I encounter is that a lot of different agreements and structure choices are tax-driven. But can you comment on that? What do you think?
Certainly critical to get the proper tax advice. Of course, we don't always want the tax choices to drive the results. For instance, if there's a better tax situation by giving a gift to a certain child through your will, but that's not the child you want to give something to, don't let that drive what you're doing for your overall estate plan. All of that said, it would always be my practice when we prepare any kind of agreements, be they operational, estate planning, succession, we always want to get professional tax advice on all of those documents to make sure we don't have any unintended consequences that could be avoided by structuring something a little bit differently.
So something that I think is probably less common, has great power, but something to think about is the prenuptial agreement or the interspousal agreement. Why is an interspousal agreement something that you commonly recommend, Ray?
What it is, it's a risk management tool. It deals essentially with what happens in the event of a couple divorcing, and it deals with trying to ensure that the farm survives the divorce so that the value of the farm continues to increase and it's more valuable to both parties. It's a way in which you can ensure that the farm continues to survive for the next generation. It's also a way in which you can structure a relationship that deals with the uncertainties of life.
Do you want to build on that?
So I think probably what precludes a lot of people from from tackling the interspousal as a document that's appropriate for them is it just feels overwhelming. And so it can be just a very specific document that deals with a particular asset. For example, shares in a farm corporation. We want to protect that from a divorce situation, or a partnership interest, or an interest in a particular quarter of land. We can make it very specific, and it doesn't have to be an all or nothing kind of a document.
Because it's a difficult document, how do you bring that up?
Well, it's interesting because I think a lot of clients come in and it's rolling around in their minds that this is something they've heard about. It might be important and useful for them, but they're really uncomfortable raising that with their kids because they think, well, that's a reflection on how I might feel about the incoming, the in-law, the daughter-in-law, the son-in-law. And so if the first time they're thinking aloud about this is in the confines of my office, that's great. We can have a conversation. I can give them some specific legal advice about that. And then in terms of strategically how to manage that in the family conversation, certainly it can always be a blame the lawyer situation. The lawyer suggests this, the lawyer thinks this is a good idea, because that's true. We certainly would be encouraging families of using these agreements and saying it's a really important piece of the business organization that is the family farm.
Well, and I think you hit on something there that you're professionally trained and you're experienced at dealing with these situations, with the language, with the ways to position it. And so that can be a role you can play as well. And Ray, I know you've told me about that as well.
Positioning is incredibly important. How you present, the notion first off of either a prenup or an interspousal. Probably in the work that I do, I deal, I would say 8 out of 10 times with interspousals versus prenups, where we have an existing farm couple that have perhaps been together for years, and we have a situation where we have one of the other parties are expecting an inheritance in the form of property, or they're looking at acquiring more land at a discount from one of the parents. A number of factors can play into this. So they're trying to sort out how do we deal with this fairly between ourselves and ensure that the farm continues regardless of what happens to our relationship. Let's come up with a plan here.
Well, and I think your ability to communicate that can be a real asset for a family. So I can appreciate why that role becomes really important. Thank you both for sharing your experiences today. If you have heard things today that resonate with you, that you recognize you have agreements that need to be addressed, Please think about that, talk about it with your family, what risks you might be taking, and bring those to your professionals, your lawyers, your accountants, your succession planners. They play a role in helping you create the documents, identify what you're missing, what you need, and what can help you get there.